Welcome to The Explainer. Today, we're digging into how English law went from a messy, chaotic patchwork of local rules to the incredibly structured court system we know today. It's a fascinating story of how order was literally forged from chaos. So here's our roadmap for this explainer. We're going to start with the main event, the clash between law and equity. Then we'll see how the common law was created, how its own rules created massive headaches, and how a rival system popped up to fix things. And we'll finish up by looking at the playbook judges still use today, the whole idea of precedent. All right, so at the very heart of this entire story is this fundamental tension, right? It's a battle between two totally different ideas of what justice should even look like. You've got strict, rigid rules on one side, and on the other, just a simple call for what's fair. Okay, think of it this way. The common law, it's like a machine. It follows a very strict set of rules, and if you win your case, it really only spits out one thing, money. But equity is more like a master craftsman. It's flexible. It can create custom-made solutions, like forcing someone to actually follow through on a contract or ordering them to tear down a wall. But here's the key. You don't have a right to these remedies. They're given out at a judge's discretion only when they think it's the truly just thing to do. So how in the world did we end up with this split in the first place? Well, to understand that, we've got to jump in the time machine and go way back, to a time when there wasn't even a single unified law for the whole country. Our story really gets going after 1066. Before the Normans invaded, England was just this hodgepodge of local customs. What was legal in one village might be illegal in the next. The new kings, they had a pretty radical idea. What if we had one law that was common to everyone? And that ambition kicked off a struggle that lasted for centuries, creating these two parallel legal systems that, believe it or not, didn't officially merge until the 1870s. To pull this off, the monarchy basically built a justice system from scratch. You had the king's personal court, the Curia Regis, that actually traveled around the country. Then you had royal justices who would ride out to towns to hold court sessions. And back in London, they set up these powerful, permanent courts to handle the big stuff: money, land, and crime. The message was loud and clear. Local justice is over. The king's law is the only law that matters now. But, and this is a huge but, this new unified system created a massive problem of its own. In its mission to create order, it became totally obsessed with procedure and paperwork. So back then, you couldn't just show up to court with a problem. No way. First, you had to go to the chancellor and literally buy a document called a writ. Think of it as a permission slip from the king. But here's the killer detail. Your specific problem had to fit perfectly into an existing, pre-written template. If your situation was even slightly different or unique, too bad, you were out of luck. It was that simple. No writ, no justice. I mean, just imagine your neighbor builds something that slowly starts flooding your farm, but there's no official writ for a neighbor-caused slow flooding. In the eyes of the common law, you didn't have a case. The system was more concerned with the forms being filled out correctly than the fact that your entire livelihood was being washed away. And even if you did manage to find a writ that fit, the only thing the court could give you was money. It couldn't actually make your neighbors stop. So, this insane rigidity, this focus on forms over fairness, it basically forced a second system into existence. A system designed to act as the law's conscience. What happened was, all these people getting turned away from the regular courts started going over their heads. They began petitioning the king himself, begging for justice. These requests ended up with his right-hand man, the chancellor. And the chancellor started developing a whole new body of law, one based not on rigid forms, but on basic principles of fairness and conscience. And that became the law of equity. Okay, so now we've got these two powerful legal systems running side by side. You can probably guess the next problem, right? With some judges following strict templates and others making decisions based on their own conscience, how do you stop the whole thing from becoming a chaotic mess? How do you make the law predictable? And this brings us to a huge, fundamental question that people still debate today. Are judges just neutral umpires applying the law that Parliament writes, or are they actually creating law with their decisions? And here's where you see a massive difference. Parliament writes laws for the future. They're proactive. But judges' decisions, they're reactive. They look backward at stuff that has already happened. And think about the consequences of that. You could do something today thinking it's completely legal, only for a court years from now to declare that your action was against the law all along. The classic thinking is that judges don't create new law, they just discover the law that was supposedly always there, just waiting for the right case to reveal it. So,
The solution to all this potential chaos is a core legal principle with a fancy Latin name, stare decisis. It literally just means to stand by what has been decided. This is the whole idea of binding precedent. It's the rule that forces courts to follow the decisions that higher courts have already made in similar cases.
All right, let's get into our final section and look at how this whole precedent thing actually works in practice. Because it's not as simple as a judge just having to copy everything that was said in a previous case. There are very specific rules of the game. And here's the most important rule. Not every single word a judge writes down in a decision becomes binding law for the future. Only the ratio decidendi is binding. It's Latin for the reason for the decision. You can think of it as the essential piece of legal reasoning, the core principle that was absolutely necessary for the judge to reach their final verdict. That's the golden nugget that future judges absolutely must follow. By contrast, pretty much everything else a judge says, their thoughts on hypothetical situations, side comments, what they think the law should be, all of that is considered obiter dictum. Now, these things said, by the way, are not binding. A future court doesn't have to follow them, but, and this is a really big but, they can be incredibly persuasive. An obiter comment from a top judge can give huge clues about where the law is heading, and it often guides how the law develops down the road. And this is the structure that keeps it all orderly. Precedent works like a waterfall. Decisions from the Supreme Court at the very top flow down and bind every single court below it. The Court of Appeals decisions bind the courts below it, and so on down the line. This strict hierarchy is the absolute backbone of legal consistency. And all of this leaves us with a final big question to think about. This whole system, born from a medieval king's desire for control, is fundamentally built on looking backwards. It creates stability and predictability, which is great. But in a world that's changing faster than ever, you have to wonder, can a system that's always looking in the rearview mirror ever really keep up with the future?